Now, the lawyer for accused number 5 in the Senzo Meyiwa murder trial has argued that her client is being denied a fair trial due to the late disclosure of the controversial second docket. Advocate Zandile Mshololo says Fisokuhle Ntuli's constitutional rights have been violated as she only received docket 375 during cross-examination of the state's first witness, Thabo Mosia. That docket implicates Kelly Khumalo, her sister Zandi, Longwe Twala and others who were in the house when the soccer star Meyiwa was killed. It has since been transferred from the Director of Public Prosecutions in Johannesburg to Pretoria. But the MPA says a decision on it will only be made once the current trial concludes.
My Lord, it is a common cause and it is evidence before this court that the applicant pleaded before this court on the 22nd of April 2022. And my Lord, it is also common cause that the second docket was disclosed or furnished to the Defense Counsel in the middle of the trial. And to be specific, my Lord, during the cross-examination of the first witness. My Lord, it is for that reason that this application is brought before this court, in order for this court to record an irregularity that has occurred.
So then the trial of the 5 men accused of killing the soccer star Senzo Meyiwa was postponed. To discuss, we're now joined by legal analyst Nthabiseng Dubuzana. Thank you for being with us as always. Does that lawyer have an argument? It does seem strange that we heard about this second docket very controversially quite a while ago. That was raised by the advocate representing 1 to 4, and only now are they in possession of the docket.
It is very strange. It ought to have been disclosed even before the trial occurred. The fact that the state may or may not have known about the docket is also quite strange. It should be that such a matter, because, for example, when a matter happens and then the accused persons are arrested in one area and then a few others are arrested later, 2 different dockets are opened. So what usually happens is they're consolidated and they're made into one. And then all the accused persons become accused under one case number. But in this situation, it never happened, which is very strange. Now, over and above that, the information of the second docket doesn't even come from the state. It comes from the defense attorney, which was advocated for, who was accused 1 to 4's attorney at the time. Now, the issue that I had at the time was that he probably prematurely put it out. It would have been a nice trump card come defense case. But in any event, it was brought out. And even though he was raising it as an issue, I recall the presiding officer saying that the evidence he is leading is inadmissible at this stage because we are not at the defense case. We are still on the state case because we're still dealing with the first witness. And then now today, the state goes and says that, no, the record shows that this thing was dealt with, it was ventilated. Just because it was recorded as Advocate Ifo was speaking does not necessarily mean that it is part of the record because it was inadmissible. So therefore, based on that and based on Section 317 that Advocate Mshololo is basing her application on, it serves to say that yes, an irregularity did happen, and the evidence of that docket was not recorded in the manner that it would be shown in transcript, in that it was part of the record. So she was right in saying that I can proceed with this matter. I believe the state is erroneous in the approach that they are dealing with today.
How serious is this for the state? And if that argument of prejudice holds up for accused number 5, then surely it would hold up for all of the accused.
It ought to be. We will wait to hear what the attorney for accused 1 to 4 says, but it should mirror what accused number 5's attorney has said today. So if the court accepts that recording and says that is now admitting this now into record, then it should apply for all the accused persons before the bench, before the court, I beg your pardon. But now also the attorney rather, for accused number 1 to 4, wanted to raise this before Advocate Mshololo addressed today. So what he was saying was that the state is saying that docket 375 is irrelevant, and yet Advocate Mshololo's application is based on 375. And today we are receiving a letter that says something completely different on case 375 versus what was said on the 26th of August. So now the presiding officer, I think, did not correlate that information together, because what that attorney was trying to bring to the attention of the court was that it can't be that docket 375 is irrelevant to these proceedings today, because the application we're about to hear solely rests on docket 375.
Yeah. And again, how serious is this? Could docket 375 bring down the current case, those 5 accused, in court?
It could. It really could. That's why in the application, Advocate Mshololo was saying that the evidence, things like pictures that were taken at the scene, any bullet casings that were taken, all of those things are relevant to the current case happening before the court. So that is an issue, that information is not going to be used in a sense for this matter that we're hearing today. That is where her issue is. And now the state's saying that, no, wait, we will wait until this matter is decided to decide what we're going to do with the other matter. How are you going to do that? Because pictures and any other investigation that happened in that docket directly relates to this one. So how are you going to use accused persons in docket 375 to be state witnesses in docket 636? I don't understand how that's going to work. It really does confuse me.
So you're saying you're critical of the MPA here. The MPA is saying that it'll wait for this trial to finish first, dealing with the one docket, and then it'll deal with the second docket. So presumably it will wait to see if the 5 are sentenced or found guilty. Is there legal rationality behind that?
I don't see it. I don't see the legal rationality behind it. For example, this current witness that is before the court that is yet to finish his evidence, because he's still under cross-examination, is the NPA saying that his evidence is different in terms of forensic and all of that from the forensic evidence that's collected in 375? What are they trying to say there? Is the photographer that took the pictures at the scene for docket 636 different from the photographer that took pictures under docket 375? How are you going to tear apart this case and make it independent of either one, 636 versus 375? I don't see how it's going to happen. But unfortunately, the accused persons have pleaded not guilty, I beg your pardon. The trial has started its part heard. So we can't exactly go de novo right now. So the matter has to proceed. This is why Advocate Mshololo is trying to cover her client and say that once this matter is done, in the event that her client is found guilty, now she has grounds for appeal to say, based on this irregularity, the SCA now has grounds to hear my appeal because I had it officially recorded in terms of Section 317, unlike it being a discussion that way it was had for a very long time with advocates before, but without it really being on record.
All right, so it may come back in the future, even after the trial. Finally, Kelly Khumalo and the people in the House say they are also being affected by this. And there must be huge sort of reputational damage and questions being asked, but then they don't have their day in court. Is that also a huge issue and complication here?
It could be. Looking at the one, firstly, the matter is being heard like live on air. So they get to hear the evidence, even if this matter does conclude and these accused persons are found not guilty, and then they happen to now be charged. They've now been privy to certain information, albeit it's not exactly the docket, the documentation that is within the docket, so they can't see exactly what is being said. But by virtue of cross-examination, they are now preparing themselves for a defense. So anything that they would have put in their A1, A2 statements in the docket may change as a result of what is currently happening. So if it was an in-camera hearing, they wouldn't know what's happening. They wouldn't know how to formulate their answers going forward. So this is actually not playing in the favor of the state yet again going forward, because now as the attorney, for Kelly Khumalo when they eventually come in, I can raise this and say, but no, this has been prejudicial already. We've heard 1, 2, 3, 4 against my clients, and therefore it's not a fair trial. So it's going to be very interesting to see how this plays out.
Yeah, so many lawyers are trying to poke holes in the state's case at the moment. Thank you for your analysis. That was Nthabiseng Dubuzana. Let's take a short break.